Hi, my name is Ethan Aitchison and I'm a law graduate in the Litigation and Dispute Resolution Group at McCabe Curwood. It's a commercial fact of life that businesses merge and, at various times, reach deals to acquire assets. It's likewise a reality that when these deals go right, these efforts generally lead to greater profitability. But when they go wrong, they can go really wrong and can expose businesses to significant liability. The Federal Court of Australia recently considered one such case that was prosecuted by the ACCC. In ACCC and Cryosite Limited 2019 FCA 116, the Federal Court considered an asset sale agreement between Cryosite Limited and Cellcare Australia Proprietary Limited for the sale of Cryosite's blood and tissue banking business. That agreement required Cryosite to refer sales inquiries regarding its stem cell banking service to Cellcare between the period of the agreement's execution and completion. The Competition and Consumer Act prevents parties entering into agreements which include a cartel provision. This is essentially where businesses agree to act together instead of competing with each other, the result of which would boost their profits while maintaining an illusion that there were still two entities in competition with one another. When that happens before a merger or asset sale agreement is completed, this is colloquially known as gun jumping. It was on this basis that the ACCC investigated the agreement and ultimately elected to commence prosecution of Cryosite, notwithstanding that the agreement didn't ultimately proceed. Now, the ACCC was successful in their prosecution on the basis that Cryosite ultimately conceded that it was in breach of the CCA. And on this basis, the court imposed penalties of $1.05 million and $50,000 in costs. Now, while this penalty is on the lower end of the spectrum, parties who the courts have found to have engaged in cartel conduct haven't always been so lucky. Just last year, Yazaki Corporation, for example, were fined $46 million in penalties where the ACCC successfully established that it had engaged in cartel conduct. So what's the takeaway from all of this? Creating a synergy between merging businesses as early as possible is important, but this case study should be kept in mind between the execution and completion of a merger or acquisition agreement. Businesses need to be careful about the steps they take to integrate or coordinate their efforts prior to the completion of a merger or acquisition, as this can cause them to run afoul of the CCA and open them up to significant liability. The Litigation and Dispute Resolution Group at McCabe Curwood has significant experience with regulatory disputes involving market regulators, including the ACCC. Reach out to McCabe Curwood if you require any additional information on this subject, or visit our website. We've covered this and ACCC related topics extensively. The details are below in the bio. Thank you for watching.